The hearing now comes back to order. I am adjourning our hearing titled Overdue Oversight of the Capital City, Part 1. And now we are starting our business meeting. The committee will please come to order. Quorum is present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 5B and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. We begin with House Joint Resolution 42, a resolution disapproving of the District of Columbia Council's Comprehensive Policing and Justice Reform Amendment Act of 2022. The committee meets today pursuant to notice to consider House Joint Resolution 42. The clerk will designate the resolution.
House Joint Resolution 42, a resolution disapproving of the District of Columbia Council's Comprehensive Policing and Justice Reform Amendment Act of 2022. I
ask unanimous consent that the resolution be considered as read and open for amendment at any point. Without objection, so ordered. I now recognize myself for 5 minutes of an opening statement on the bill. Today we're considering Representative Clyde's House Joint Resolution 42, a resolution disapproving of the District of Columbia Council's Comprehensive Policing and Justice Reform Amendment Act of 2022. The men and women of the Metropolitan Police Department serve their community every day to help keep it safe and secure. In doing so, they place themselves in potentially dangerous situations regularly to protect others. And yet, progressive policies from the D.C. Council continue to hamstring district officers and needlessly place them in an unsafe situation. The D.C. Council's Comprehensive Policing and Justice Reform Amendment Act of 2022 does just that. It requires untenable barriers officers must overcome to don riot gear for their own protection. It creates a public database with an officer's personally identifiable information, allowing for activists to harass officers and their families. It also creates additional liability for officers that are not found in other police departments. These are just a few of the many impractical and outrageous proposals of the legislation. The D.C. Police have seen over 1,190 officers leave the force since the beginning of 2020. 1,190 officers have left the force in 3 years. That's about 1/3 of the police department. Nearly 40% of those officers resigned, choosing to leave the department instead of dealing with the increasingly impossible burdens placed on them by the council. Over that same period, crime has soared in the district. The council has continued to overlook its law enforcement officers in favor of progressive, soft-on-crime policies that only benefit criminals. The citizens of D.C. and visitors to our nation's capital deserve to feel safe, and our police deserve to have the resources to ensure safety for all. The Comprehensive Policing and Justice Reform Amendment Act does neither of those things. If the D.C. Council wants to continue down this path, they will have to answer to this Congress. And we are not alone. The D.C. Police Union, representing 3,500 members, the U.S. Capitol Police Labor Committee, the California Coalition of Law Enforcement Associations, the Fullerton Police Officers Association, and the Las Vegas Police Protective Association are strongly in favor of HJ Resolution 42. We see such broad support for this disapproval resolution from organizations across the nation because other jurisdictions know just how awful the D.C. Council's anti-policing reforms would be as a precedent for America's cities. Additionally, D.C. Mayor Muriel Bowser declined to sign this legislation into law. That should be a signal of how extreme it is. But the D.C. Council did not listen and proceeded to override her signature and pass it anyway. I call on all of my colleagues to join me in supporting Mr. Clyde's resolution disapproving of the Comprehensive Policing and Justice Reform Amendment Act of 2022. 31 House Democrats and 31 Senate Democrats have already joined President Biden and House Republicans this year to block another ill-informed D.C. Council legislative action by disapproving of the revised Criminal Code Act of 2022. The dangerous policing reforms addressed by HJ Resolution 42 are equally bad, if not worse, for the current crime epidemic in D.C. We must ensure that these pro-crime policies are not allowed in our nation's capital. I encourage all of my colleagues on this committee to join me in supporting HJ Resolution 42 to continue these efforts to restore law and order to D.C. Who else seeks recognition on this resolution? Chair now recognizes the ranking member for 5 minutes.
And thank you very kindly, Mr. Chairman. I want to start just by pointing out to my colleagues that most of the debate and discussion we just heard was really about the last bill, about HJ Res 26, which already passed out of the House and passed the Senate. And people were rehashing all of the discussion about the definition of murder and carjacking and all the various substantive offenses. That has nothing to do with what we're doing here today. HJ Resolution 42 is about the police department. And as the chairman of the Council of the District of Columbia just explained, we're here because the union was very unhappy with the fact that the district council unanimously decided to remove from collective bargaining questions of discipline of particular members. Now, why did they do that? This is an issue that's come up, certainly came up in Maryland. We debated the exact same thing in the Maryland legislature. It's been debated all over the country. Why did they decide to do that? And certain jurisdictions go one way, certain jurisdictions go the other. Well, here's some of the examples that they talked about and that are part of the legislative record. There was one officer who beat up a suspect, striking him multiple times in the head. He was criminally convicted in court of assault and sentenced to 30 days in jail with 3 years of probation and 500 hours of community service, only to be reinstated under the arbitration system that is provided for in their collective bargaining contract. Another police officer sexually assaulted a young woman and was convicted of misdemeanor sexual abuse, but then was reinstated again under the arbitration process. Another confessed to abusing a child, was convicted of child abuse, sentenced to 5 years of probation, and yet was reinstated. So the D.C. Council decided to end, as a matter of collective bargaining, discipline of officers, and the union was very upset about it. Now, what else is in there? Well, exactly the kinds of things that are taking place with police reforms across the country. Expanding the current ban on chokeholds to include other kinds of restraints that pose a severe risk of death. Enhancing transparency by improving public access to body-worn camera footage after an officer-involved death or serious use of force takes place. Strengthening the Civilian Police Complaint Review Office. Prohibiting the police department from hiring officers from other law enforcement agencies who have committed serious misconduct, were terminated or forced to resign for disciplinary reasons, or resigned to avoid adverse action. Empowers the chief of police to establish internal policies and procedures for discipline. Requires schools to report data on school-based arrests. Enhances transparency around the use of overtime, and so on. All of these classically local personnel matters that go right to the heart of democratic self-government. And the police union is upset because they want to be able to bargain to get people reinstated who've been convicted of crimes, including child sexual abuse or sexual assault. And this is what our colleagues are being carried away with, but they're using rhetoric about the last piece of legislation about carjacking and murder and so on, and whatever the merits of that debate, that's over. And now what we're talking about is simply the question of whether the District of Columbia gets to have control over its own police department. The D.C. Council unanimously came forward in legislation that was not vetoed by the mayor of the District of Columbia to say that they stand by the Comprehensive Policing and Justice Amendment Act of 2022. And either we're going to believe in home rule or we're not. It was adopted in 1973. Some of our colleagues say, well, there's Article 1, Section 8, Clause 17 of the Constitution, which says Congress exercises exclusive legislation. But we've delegated over local matters to the District Council and the mayor to have their system of government to govern. And we should not sit as a 535-person city council in order to be deciding all of these things. We've got much more important things to do, like addressing the gun violence epidemic in America, or even considering the admission of new states like Washington, D.C. or Puerto Rico that are asking for their democratic rights. Thank you, Mr. Chairman. I yield back to you.
Who else seeks recognition on the resolution? Who? Okay. Chair recognizes Ms. Norton.
Let me begin by saying to this committee, keep your hands off D.C., please. It is true that Congress has the constitutional authority to legislate on local D.C. matters, but it is false that Congress has a constitutional obligation, has an obligation or responsibility to do so. Instead of legislation on local D.C. matters, remember that's a choice. This disapproval resolution is a choice. I remind my Republican colleagues who claim to revere the founders what James Madison said in Federalist 43 about the residents of the federal district, and I'm quoting, "A municipal legislature for local purposes derived from their own suffrages will of course be allowed them," end quote. The Supreme Court has held that Congress may delegate quote, full legislative power, and I'm quoting that, full legislative power to D.C. on local D.C. matters. Today, this committee is marking up profoundly undemocratic, paternalistic legislation. This one-sentence legislation would nullify legislation enacted by D.C.'s duly elected representatives. D.C.'s local legislature, the D.C. Council, has 13 members elected by D.C. residents. If D.C. residents do not like how the members vote, they can vote them out of office. This is called democracy. After the murder of George Floyd, many states and D.C. passed police accountability and transparency legislation. The Council has repeatedly passed emergency, temporary, and permanent versions of police accountability and transparency legislation. Congress requires the Council to pass the permanent version of legislation twice, separated by at least 13 days. The Council passed the legislation that is the subject of this disapproval resolution by votes of 11-0 and 13-0. The Congress has 535 voting members. The members are elected by the residents of the several states. None are elected by or accountable to D.C. residents. If D.C. residents do not like how the members vote, even on legislation that applies only to D.C., such as this disapproval resolution, they cannot vote the members out of office. They cannot vote the members out of office. Members who vote in favor of this disapproval resolution are choosing to substitute their policy judgment for the judgment of D.C. duly elected representatives. They will choose to govern D.C. without its consent. I can only conclude that this committee believes that D.C. residents, the majority of whom are black and brown, are either unworthy or incapable of governing themselves. D.C. residents are not children. They do not need protection from the decisions of their duly elected representatives by members of Congress from Kentucky, Georgia, or anywhere else. The Revolutionary War was fought to give consent to the governed and to end taxation without representation. Yet the nearly 700,000 residents cannot vote on any action taken by Congress, whether on national or local D.C. matters, while paying full federal taxes. Indeed, D.C. pays more federal taxes per capita than any state and more total taxes in 23 states. If this committee cared about democratic principles or D.C. residents, it would be marking up my D.C. statehood bill, the Washington, D.C. Admission Act, instead. Congress has the constitutional authority to admit the state of Washington, D.C. This committee is choosing not to. that it is a choice. Mr. Chairman, I ask unanimous consent to submit into the record a letter from the leaders of civil rights organizations led by the Legal Defense Fund opposing this disapproval resolution.
Without objection, so ordered.
Will the gentlelady yield?
I yield.
Thank you kindly. I just want to point out that the local legislation they propose to overthrow today creates a publicly accessible database for sustained allegations of police misconduct in cases involving an officer's commission of a crime. It was said before that this was for unsustained. No, it's only for sustained allegations. Why wouldn't every citizen want to know if there's an officer coming from another jurisdiction who's been convicted of an assault, a rape, a robbery, whatever it might be? Thank you, and I yield back to you.
Chair recognizes Mr. Timmons.
Thank you, Mr. Chairman. Congresswoman, would you yield for a question? I'm just curious about what you said regarding D.C. statehood. Would you yield for a question, ma'am?
Of course.
Okay, sorry. Can I yield to you for a question? I have a question for you, I'm sorry. In 2009, the Senate passed the D.C. statehood bill with 63 votes, and the House didn't take it up. The House had 235 Democrats in it. Could you articulate what happened in 2009 and why it didn't get across the finish line then? I was not here.
There was a gun amendment attached to it to wipe out D.C.'s gun laws.
Sorry, so the Speaker controlled the House, and it came out of the Senate, and
The
Democrats...
gun amendment attached to it was the problem.
Okay, but the Speaker controls the Rules Committee, and the Speaker controls the floor. So what you're saying is that in 2009, when the Democrats had the House,
It really wasn't statehood. It was just this vote. That vote.
Okay, so my understanding in 2009, there was a statehood bill out of the Senate. So there was not a statehood bill. That was a different issue?
Yes.
Okay, so this has not been ongoing. But the bill that came out of the Senate, S-160, what did it do if not address this concern that you have?
There was a House vote only.
The CRS report I have says that it got out of the Senate 63 to...
Would the gentleman yield?
Yes, please.
The legislation itself contemplated granting the District of Columbia a voting representative, but only in the House, not in the Senate. So it was not a statehood bill, strictly speaking. It was and it raised constitutional questions, but it was just to provide for one seat for the District of Columbia with a voting
It
representative.
was just to create a new
Exactly.
congressional seat where you would have full voting rights on the floor as opposed to just in committee.
Exactly.
Okay, no, I appreciate that. Thank you. It's helpful to understand the legislative history behind this. Thank you. Mr. Chairman, I yield back.
Does any other member seek recognition?
Mr. Chairman.
Chair recognizes Mr. Kassar.
Thank you, Chairman. As the ranking member mentioned, I believe that we would be, by moving this forward, repealing important protections for people that should, frankly, have bipartisan support. Subtitle A of the D.C. Justice Reform Act that would be overridden by the Congress prohibits the use of chokeholds and neck restraints in a stronger way. In fact, they had been banned in 1985 by D.C., and this would just make sure that that ban is properly enforced. And I would yield some of my time to hear from anybody in the majority, just for a few seconds, to know whether or not the majority supports actually banning chokeholds, or whether or not they would like for chokeholds to be allowed in the city of D.C.
The gentleman yield.
Yes, sir. Yeah, and I have a few questions, so if 10 or 20 seconds would be great, sir.
I'll ask to be recognized, Mr. Speaker. I'm probably the only one here that has actually affected arrest through the use of vascular compression, chokeholds. We haven't trained chokeholds in many decades. They don't work. Vascular compression is what we train, and they've saved countless thousands of lives. But I'll ask to be recognized. Thank you, sir.
Thank you. Furthermore, Subtitle B would allow for body-worn camera footage to quickly be released to the public in cases of critical incidents. I believe, having done oversight and accountability in prior jobs and now here on this committee, that the publicly available body camera footage is a good thing so that we can ensure that folks are held accountable or exonerated based on the facts. And I think body-worn camera has taken things a long way, where we have a lot of police departments really supportive of having body-worn camera for those reasons. So I would again ask and want to understand whether the majority believes that we should be keeping this body-worn camera footage from the
Gentleman
public.
yield.
Yes, sir.
The original users of body cameras, good sir, were police officers who, far before it was mandated by the department, some of us that were tactical police officers began a practice of wearing body cameras to protect ourselves against false allegation. And I yield.
Yes, sir. And I have seen and heard that ourselves, right? When we bought body-worn cameras, oftentimes in police departments, was to say, look, we know some folks have their own. Let's have them for everyone. What we would ultimately be doing by overriding this DC reform would be getting rid of the transparency reforms here that DC moved forward with. And so, again, I would urge that we vote no on the resolution before us today, because why would we take away transparency on body-worn cameras? One more question, I think right to the ranking member's point. One of the most critical reforms that folks are talking about overriding today are reforms to make it so that somebody that was criminally convicted for assault while on the job can't get back onto the force. So I, again, would yield to better understand why we would overturn that reform. Why would we be supporting a measure that allows it so that people criminally convicted for assault on the job could get back onto the force?
Do you want me to just go ahead and say this?
At the risk of repeating myself, the gentleman yield as his time expired.
No, you've got time.
Yeah, so the hiring practices from department to department has been a matter of recognized procedure across the country for a long time. Chiefs talk to former chiefs, talk to former supervisors. So this communication is ongoing, but I mean, there's never an instance where you hire someone for your department that you don't talk to the previous department and the supervisors and guys you work with. So you know these histories.
100%. And in this case, the police chief wants some of these reforms enacted so that they aren't forced to have people come back to the force that they wanted to get rid of in the first place.
Right, but what I'm saying is there's nothing stopping those communications right now.
No, that
It's a
is
matter of
being
common.
stopped.
I yield.
Yeah, what we got today in testimony is that because of the police association's tactics, people that were convicted of crime had to come back and be allowed to work back on the force. And what we're doing by passing this bill is not supporting public safety by having some of those officers that are dangerous come back onto the police force. What we heard in this committee hearing was people calling DC and public schools inmate factories, people calling Black Lives Matter a criminal cartel. It is not rational, and I urge that we vote no against this bill.
Did any other members seek recognition on the resolution? Seeing none, the question is on favorably reporting HJ Resolution 42. All those in favor signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported.
Seeking recorded vote, Mr. Chairman.
Recorded vote is ordered. And we're going to recess. Okay. Because we have subcommittee meetings scheduled right now, we're going to postpone a recess until after the subcommittee hearings adjourn or 4 p.m., whichever is first. The committee is now in recess.
This hearing on the Subcommittee on Economic Growth, Energy Policy, and Regulatory Affairs will come to order. I want to welcome everyone for coming. Without objection, the chair may declare a recess at any time. I recognize myself for the purpose of making an opening statement. In the 118th Congress, the Subcommittee on Economic Growth, Energy Policy, and Regulatory Affairs has taken its mission seriously to conduct oversight over the federal government. This subcommittee has already held 2 hearings examining the Biden administration's misuse of government power. We have explored how this administration continues to erode our country's energy security by depleting the Strategic Petroleum Reserve. And we've also looked into the administration's abuse of the administrative state, burdening the Second Amendment rights of law-abiding gun owners. Today, we're going to turn to the Biden administration's policies on inflation and energy prices. Every American is suffering from inflation. I think we can all agree on that, and the rising energy prices. But Americans with low and fixed incomes are being the hardest hit. This focus stands in stark contrast to the last Congress, where